The men who were arrested and tried for the murder of Free State farm manager Brendin Horner are free this weekend. The state's case crumbled, and prosecutors eventually conceded that they don't have enough evidence against Sekwetje, Mahlamba and Sekola, Matlaletsa. A judge acquitted the pair yesterday, and the legal teams reportedly intend to take legal action for wrongful arrest and malicious prosecution. DNA samples taken from the murder scene did not match those of Mahlamba and Matlaletsa, and a witness whose sworn statement linked them to the murder changed his tune. To talk more about this then, we're joined by criminal law expert Ian Alice. Ian, a very good evening to you. Welcome to News at Prime. I touched on it slightly, but let's speak a bit more about the basis on which the state's case basically crumbled spectacularly this week.
Good evening to Bakile and good evening to the viewers. Very simply put, there's different types of evidence. There's your physical evidence, your forensic evidence, and your testamentary evidence. Your physical is basically your murder weapon, your bloody clothes, the getting caught red-handed type of philosophy. Your testimony, which is your eyewitness statements and everybody corroborating if they can't catch you red-handed, that there was something, that they heard something, and combines a bit of hearsay evidence and the forensic evidence with what the state was able to get, whether the blood samples, the DNA tied up. The problem for the state is that nothing tied up in these circumstances. There was very little physical evidence to go on to actually prove that these were the parties. The DNA evidence certainly never tied up, and there was no, and the blood wasn't found to be the correct blood. The clothing there was an issue with, and the testamentary evidence just fell completely to shreds, with the chief eyewitness, I think it was Kambule, being retracting his statement and changing his version and alleging police coercion, which all of those are never going to be able, unless they tie in together, will always lead to an acquittal in the circumstances.
And I use spectacularly, this is perhaps the most shocking and embarrassing way in which a prosecution team can fail to argue a case. Let's address what we are reading now in some media reports, that the representatives for the two accused now want to pursue cases for wrongful arrest and malicious prosecution. Is there enough grounds to argue that successfully?
Not necessarily, because it's a different burden of proof. Is just because you're acquitted doesn't actually mean you're innocent. It means it cannot be proved that you were guilty beyond a reasonable doubt. So without casting any dispersions of what the defense actually does have to say, there is a risk that they could still be deemed that the conduct of the police was not unlawful. It's just simply they never had enough evidence to secure a conviction. Simply having not insufficient evidence to procure a conviction does not automatically result in an unlawful arrest or an unlawful prosecution. If the police acted in an orderly type of manner, there was no indiscretions, there was no bad faith in the investigations, and there was an honest belief that from the proof and from what was garnered through the investigation, that the two were guilty, there's enough to sustain a charge. It just wasn't sufficient to sustain a conviction or anything or any guilty verdict, if one could go ahead and say that.
And legally,
so a lack of.
Sorry, Ian. Legally, when one believes that they've been wrongfully arrested or been the victim of a malicious prosecution, how do you proceed with that? Would that be an issue that you go back to the trial court or separately?
No, it's a civil action. It's a completely civil action. They will need, however, copies of the docket to show what steps were taken by the police to determine whether or not there was a genuine investigation or if it was a rushed and contaminated and an investigation that was basically, if one could call it, a nonsense type of an investigation. There was no proof. They knew that there was no proof. They knew that they didn't have any evidence, and they still proceeded. So there's got to be an element of intentional spite behind it in order to go ahead and in order to charge to garner success in an unlawful and malicious prosecution suit.
And
and it's also a totally different burden of proof that needs to be faced.
Sorry, I'd imagine that that's where the defense would now want to rely on the claim by the initial eyewitness who says he was harassed and abused by police officers to stick to a statement that he now says is simply not true as far as placing blood on the clothes of the accused. That would be key to arguing that perhaps the officers, at the very least, were intent on pinning this crime on the two men.
That is pretty damning from the state's perspective, is the fact that there was coercion and witnesses were bullied and intimidated into making statements, knowing full well that it was an untrue statement. That will be damaging to them. If it was basically based on hearsay and exaggeration, then it won't be deemed as an unlawful arrest or a malicious prosecution. The problem is when you've got an eyewitness who is changing their version, their credibility is also going to be looked at in a circumspect manner as to what they're aiming to achieve.
And in terms of
to deal with their credibility.
Sorry, Ian, I keep speaking over you slightly because I think there's a delay or our line is breaking, but we can still hear you clearly, so that's fine. I wanted to ask you about the consequences if it's a civil process, right? Is it up to the defense to choose if they're going after individual officers or the SAPS as a whole? And where the NPA is concerned, can they just claim that they are the victims of poor investigative work by the officers?
What will normally happen in a situation like this is that there will be a complaint and a letter will be sent off to the state advocate's office as well as the minister to indicate that there's an intention to sue for unlawful prosecution. Thereafter, the election does rest with the defense as to whether they want to proceed against the minister and the police, or if they're going to cite the individual officers. Often they don't cite the individual officers, but just go after the ministry of police for the conduct of them, as they're responsible for the conduct of all of their employees and police who fall under the banner.
Criminal law expert Ian Ellis, good to speak to you tonight, sir. Thank you for your time.
Thank you very much.